works. Seems like we got all of ours here. We've actually got Debbie in the studio, so that is something. I think that in itself is a reason to say hello again. This is Ben Hitchcock Frost talking to you today. We've got just really one topic that we're going to do right now, which is as far as I'm always the last one to find out, but Debbie sent a email to Matt White, and so we're just going to go over the response. And just for the setup here, um, if you haven't seen the hot mic recording, that's sort of what's feeding this here. The judge on a case, Larissa Benitez Morgan, recorded herself talking to Matt White. And one of the things the judge says is that all of my pleadings or something like that are full of lies. And Matt White seems to agree with that. He, in fact, says that he's seen it. And then there's another comment. A judge Carlson comes in the room and says that there's some guys with handcuffs. And the judge ALJ Larissa Benitez Morgan, who's still employed by the state of Wisconsin, by the way, says, "Well, we've got 4 officers here to take Ben out here in handcuffs." And Matt White, who's the head of all the investigators, says, "Unfortunately." As unfortunately they didn't arrest me. So just to be clear, there's this process. It's unlike any other court, this because it's workers' court, but keep in mind, you file a complaint, they do an investigation. You either get a probable cause or a no probable cause. If you get a no probable cause, you end up spinning your gears for 8, 9, 10 months, a year, 2 years, who
Oh,
knows?
easily, yeah, 2 years, yeah.
Easily. If you get the actual probable cause, which is extremely rare, definitely less than a quarter, probably like less than 20%, based on our numbers.
Yeah.
Get that, then you actually get a hearing, a regular hearing. If you win the probable cause hearing, which you may not even win it, then you get a real hearing. That's how that works. So the
Hmm.
person who's in charge of all the supervises all of these decisions. And really, as far as everything I know about how Wisconsin departments work, he's the supervisor signs off on all the decisions. They may not know all the things, but the facts of the case, the investigator, though, is going to take whatever decision it is and put that to them. Now, to be fair to Mr. White, there is a section chief between him and the actual investigator. That's Amy Russell. Okay. But once again, this person here who says that I'm a liar and it's unfortunate that when I'm not arrested, that person is in charge of all the investigations. So let's hear what he has to say about this.
Okay, right. So I emailed him on October 30th at 2:28 p.m. And I also included Megan Burns, Ramona Natera, Amy Pekachek, however you say her name, and Maria Salsor, because those are administrators, decision makers in the ERD. And I've actually had discussions with them previously. So uh, it wouldn't be rare for me to know who they are and to pick them. And I emailed them after I watched the hot mic video, like Ben said, because I'm sitting here just in awe. So I write, "Hello, I am emailing because I have a concern about the ERD handling my investigation and quasi adjudication of my latest ERD complaint for wrongful termination. In addition to withholding of ERD records, I requested regarding Jeremiah Holiday on November 15th, 2021, which include documents I created as part of my complaint, to the illegal adversarial quashing of a subpoena and granting an adversarial 30-day stay in March 2022 on behalf of the respondent, Milwaukee Board of School Directors, when no ALJ was even arrested to the case. And now
Well,
to learn,
whoa, 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 whoa. Okay, I'm sorry. And all of us, we're laughing here because we know that, but that's almost 3 years ago, to the week, almost. But let's just back up, and I can walk you through this pretty clearly. You knew about a complaint that Jeremiah Holiday filed against MPS, right?
right. Well, and the important part of this, Ben, really is all that people need to know is that I am laying out a series of events that have happened over a period of time that clearly show that the individual that I'm addressing this to, Matt White, has done things that have been very adversarial and negatively impact my ability to get fair treatment.
So one of those things is you asked for records. He told you those records didn't exist
Yep,
when they existed.
I asked for them by name, written down. He flat out told me, and I said, I asked him directly, "Are you saying these don't exist?" He told me they did not exist, and
And
when indeed they did.
and then he gave the your employer a 30-day stay in discovery, right?
He quashed a subpoena with less than 24 hours, the subpoena of Matt Chasen,
Okay.
with less than 24 hours to go. And then he also granted a 30-day stay in my first case.
And it's
Yes.
my opinion he had no power to do either of those things. It's also the case that he called ALJ Alice DeLeo to discuss the matter. As far as we know, he discussed it with the administrator and other things. And also, I think even more damning is he did this because he got an email saying this is the MPS media case.
Yes, and then we unveiled that they have
Right.
been chit-chatting about me for quite some time and, had nicknames for me and so forth.
So you've been democratically criticizing Matt White for some time. Fair?
Fair enough, fair
Okay.
enough. And he knows who I am every time he sees me, and he tells me that. So, to continue, and I said, and now to learn that ERD judges openly discuss disdain towards my choice of representation, yours truly over there, selecting cases that have been Ben Hitchcock Cross assigned to her because she, quote, will eat bullies like him for breakfast and lunch, is alarming to me. I have seen the judges call my attorney a jerk. I have witnessed them call the police on him and plan the location of proceedings based on his presence, and this worries me deeply. To be clear, I'm stating that I do not believe that I will be able to receive an unbiased investigation or hearing based on the aforementioned examples, and many more not listed. I should have put in there also that one of your judges is suing me for $750,000. I didn't put that in though.
Right? Who can it's
I forgot
sometimes we
that part.
forget about that part.
But I did make note that that wasn't everything.
Go.
I am asking what my options are for proceeding through formal adjudication of my case where there is a guarantee that the proceedings will be conducted in a way that is free of bias. Thank you for your response and please acknowledge the receipt of this email.
Now, because I love the way you set that up because you have a right to have these proceedings free from bias, right? That's
I
clear.
thought so.
The statute, the little thing called the due process clause of the
Yeah, and the whole
Constitution,
equal rights thing.
right? All that. Okay, so you're supposed to have a fair, and it's your right. It's not like somebody else's, right?
Right.
Okay, so I'm expecting that they're going to give you some options that preserve your right to a fair hearing, right?
Well, we'll see.
Well, I guess we'll see.
So Matt White, emails me back um, right away within less than 30 minutes. He keeps everybody CC'd on it except for Amy P. Chichek.
Pachacek, I've also heard Pahasek. And
Yeah,
the
that's
main thing to keep in mind is that it took some work to remove her.
yes. He cognizantly had to remove her, kept everybody else on except her. And he writes, Dr. Keither, I received your email. Regarding your investigation, you have the option to withdraw from the Equal Rights Division process and ask the EEOC to conduct the initial investigation into the issue of probable cause. Yeah, give it to our neighbor across the street
Well,
or across the hall.
and so everybody understands there's a federal process and a state process that are similar but not the same. And it's also important to understand that these things get cross-filed. So when you file something with the ERD, it's also cross-filed with the EEOC. But what I'm hearing is that your number one choice that he's offering you is to remove, because if you go to at this point, if you were to go to the EEOC, you would withdraw your ERD claims.
Right.
Right. So to the extent that they're not identical, all of those claims would go away.
They would, and they would probably give me a letter stating you chose to withdraw and it is withdrawn with prejudice.
Right.
Meaning don't come back here again
Right.
trying to redo this because you are leaving because we cannot
On your own choice.
Right. You're choosing to leave. The fact that we're prejudiced, is making me leave, but they're not going to take any part of that.
I can't even resist. ALJ Gelhard in the Stolar case, so when we didn't he invited us to do the exact same thing. He said, if you think I'm biased, you should remove yourself to the EEOC. Okay. And then when we didn't remove to the EEOC and we said, you need to remove yourself because you're biased, you know what he came back and said? The fact that you didn't go to the EEOC means that you don't believe that I'm biased.
Right. The fact that you didn't give yourself a different experience because I can't control my behaviors, you're supposed to take that penalty, I
Right.
guess is his
You didn't
statement.
accept the
Right.
abuse,
Right.
right?
Yeah.
Gladfully. So then it's your fault.
Yeah. That's their opinion. I mean, and I've witnessed it. Even I don't do I'm not in hearings full time or anything. I just go here and there. And every time I go to one, the judge makes a comment. Instead of having the legal argument that they're supposed to be having in their role, they want to just say, you know what, take it up with Lurk, take it up with Lurk, because for that judge, it's just a day's work. But for the complainant, it is years of blood, sweat, and tears and financial exhaustion that this judge just shrugs off as, when can we go to lunch?
Well, and the principle of the thing too, right? Some people are there just because they were called the N-word,
Right.
right? I mean, and that's for no other reason.
Yeah, and they don't want to be bothered with any of the complexities of law that might exist and the way people could interpret them. They don't want to deal with that. They just want to bark at you. I mean, Delau was famous for that. She just barks at everybody who wants to have a two-way discussion, which involves active listening on their part and responsiveness. They don't get it. But this goes on. So he says there are no alternative state level pathways for initial investigation of these complaints. No,
With sorry,
oh,
sorry, with Matt White in place,
yeah, with
right? Because
under his watch.
I could find an alternative is, for example, no Matt White. Another alternative is Matt White changes his ways and sees the light that maybe it's not okay to try to have attorneys arrested and to think that they're full liars and to be biased. I mean that's another possibility. That's another pathway. You
Or
might say, yeah.
if you have all these people who are biased and they all have to be recused because they know they are, then you have to pay for someone to come in and do the work that you cannot do. Whether or you have to have a reciprocal contract with the DHA, the Division of Hearing and Appeals, like they've seemed to found figure that out in other cases. Why should I have to carry the burden? They did it for another
Well, that's
person.
what he's saying. He's saying that there's a mechanism to have a hearing somewhere else, but right now there's no way to have uh, another department do his job for him so that it's
The
unbiased,
investigation.
right?
No matter what the investigator decides, you will be able to get your case certified for hearing, either on the merits or as an appeal of any determination of no probable cause. You can make a motion. I have to make a motion, so I have to pay you to make a motion
Okay.
to the assigned administrative law judge, and they can rule on whether they have a conflict with respect to your case. One of your judges is suing me.
Right.
So
Well,
that's, yeah.
but also, do you
And
think
he's the main bad actor in the
but he
case.
knows this guy knows the difference between probable cause and no probable cause.
Mhm.
And he knows that it's even if you win at no probable cause, which you might have a biased judge or all the rest, you're still a year of your life and forty,
Right.
sixty
Yeah.
thousand dollars. He
Yeah.
knows that, right?
Right. And then certain people won't even be here at that time. So like they can do something right now, but not have to pay for the price for it later on because they'll be gone. They'll be retired. They'll be in another department because we constantly shift people around and they'll be, it will be nobody's problem. Then he says, alternately, you can request a right to sue letter from the EEOC and commence your case in federal court. That's what he says.
Okay.
So
So I guess that's
those are my equal rights.
we
My
have
equal rights.
we've demanded, I think, here that the this equal rights division reform itself, and their opening offer is for us to go away.
And by the way, they need to admit again, we have their open records requests. Their own employees have written to one another about how that place is imploding on itself. I have internal emails where they are talking about unfair treatment between different people. Um, Judges complaining about other employees that are there and vice versa. So for me as an outsider to be able to have enough data to see that this is happening means it's at a critical crisis mode there. Like they're not functional in terms of what they're supposed to be doing.
Well, even I mean, even in the brief videos that we have, in the hallway, it didn't seem like there was much work getting done.
That place has been empty. When I went in 2021, it was empty. Nobody was there, and it is still empty. It's like going on 3 4 years now of that place being a ghost town. And I guess I would start to say, why are we investing in this real estate if people aren't going to show up to it? I mean, if now everything's been parsed out, and I don't care if they're there where they're doing their job really, as long as they're fulfilling their service, but they're not fulfilling that either. So I
Well,
mean,
right. I mean, even if I don't know what their job is, I don't know what their work is. I wasn't really monitoring them. And so I won't comment on that. But I will say that while I was in the building, there seemed to be a lot of employees who had a lot of time to involve themselves in our case.
right, right.
And that
Well,
I
and the open records request that I made was a big to do that day, and I'm just kind of like, open record requests should be very standard and procedural. Like, why should it involve 15 people coming over here and having discussions and going back and forth and back and forth? Like, it's just very cut and dry. You ask for this, you get it. Like, but they seem to be focusing on different things. Um,
right, and I heard this comment this weekend. Somebody made uh like a meta video of the hot mic thing. So of
mm,
course I had to watch it, right? And there's this comment there that I think is just brilliant because and it's something like this. You judge get watched by videos all day long
right,
on the street, going into the building, but you don't have any problem with that when the police are the ones that are behind, right? It's just that when the citizens are the ones that are putting the attention on the bureaucrats, that's when they're like they they can't do any work except focus in on making sure that that's and just think about right. I mean, we they went through uh three drafts of this pre-hearing order between Maria Seltzer and the judge to for the sole purpose of keeping us out.
mm-hmm. Yes, and then even Benitez Morgan, that makes me think too how she made sure to tell you, I don't do pictures, I don't do videos. Um, if I said that at my place of employment, if when they recorded me all the time when I was presenting, and by the way, I was proud to be recorded because I thought my work was high quality and I wanted it to be shared. Why is she, and I even said this at the hearing, I said, what is the downside of recording? Um, and she said something stupid like, I don't like the way I look on film. What? Um,
But
then
why, just for example, if that was true, if that was the true reason, why, how does that even
it's
begin to
irrelevant.
equate with the fact that the worker has the right to show other people what's going on at a hearing?
Right. I agree. And that's why, I mean, even like with Calvin asking me, who did you send my filings to? Well, you wrote them. Why aren't you proud of what you wrote? Wouldn't you show it to everybody? Go ahead and show them. I mean, you wrote that about me. Share it with everybody. It's a public forum. Like, if you aren't going to come with ready to show all of your colors, then don't write it.
Well, but these are okay. And those are two different. So that's an attorney putting a document in the public record and then saying what's you can't talk about the documents that I put in the public record.
Right.
Okay,
Right.
and that's one level. But I think this is another step where
It
these are
is.
public employees who are being paid to conduct a public a hearing, which should be public,
Right.
are saying no, you can't watch us because it makes us
Right.
uncomfortable.
But the concept is the same. Like, if you are doing something that is within, if you're doing high quality work, you shouldn't care that people are watching you. I mean, that's all it is. Whether in a
I,
public
I get it. I think it's
official should expect to have people watching.
well, we should expect our public officials to be doing high quality work. So therefore, their work should be open to us in public.
Right.
Or if they're not, then we should assume that they're not doing high quality work.
Well, right. And the fact that you want to fight about whether or not you should be recorded makes me think that you're not comfortable in what you're doing.
Right? Because if it was anybody else, they'd say, "What? Do you have something to hide?"
Right. I mean, they want to record teachers all the time. They have stuff in the hallways. They have stuff, they recorded us on our job, like, you know, and if you're not doing anything wrong, then you wouldn't really be so concerned about all those recordings.
Because it's not about the recordings; it's about the free speech behind the
Right,
recordings.
right. So, and it reveals way too much on them. And it only took, I'll just say this too, those of you who watched the hot mic thing, um, that judge kind of, really boxed herself in there, because what's funny is she demanded to be the only one who was recording. So we conceded to that and let her be the only one
Well,
to
because she
record.
did have armed guards with her,
And
right?
she had the police there, and
Right.
she was basically, and she wanted me to do a legal argument, to the Supreme Court why I should be sitting there, whatever. So she demanded to be the only one recording, and then she wound up tattletaling on herself because she had the recording going at the times when she probably shouldn't have had the recording going. And so I would have never been able to capture that on mine because I wasn't in her pocket. But it took her one time of putting a recorder on herself to totally reveal her disdain for public visibility, for people being interested in what she does as a public equal rights judge of all things. And, a traffic person or whatever, they might not. This is a person who's supposed to be upholding equal rights for citizens at a time in our country when it's so in dire need, and she has these horrible opinions.
And the last thing that I'll say is, uh, she the lack of awareness, I think, is exemplified by this particular instance, which is her saying that nobody should be harassed in the workplace.
Yes, she made herself being harassed. Yes.
And that, because it was really about, I mean, thank you for saying that, because I think although she was using other examples, she was really talking about herself.
She was talking about herself. Yes, and she was talking about the other opposing counsel who made herself the centerpiece of this real victim's hearing, and took the time, energy, and consumed all of that. This person has waited 3 or 4 years now, because her stuff was in 2020. So 4 years she's toiled away. And now opposing counsel comes in and calls the police multiple times because she's being a victim, harassed. And then the judge, by extension, thinks, oh, yeah, she's well within her reason to call the police. And I actually agree. I don't think anybody from the public should be watching these
I
things.
asked you to cease and desist.
Yeah. So, anyways, that's the state of equal rights in Wisconsin. And anybody who thinks that they are going to go there and, have that mission upheld, I would say keep a close eye on everything that's going on, closer than you
Well, but
would
that's,
even think you had to.
and I hear that, and I'm going to say this. I think that the main lesson that I've learned is that it has to be recorded. Everything that you go from all of your interactions with them need to be recorded. I
They
think
absolutely do.
that's the main lesson here, and I think there's more lessons and more things that are coming up. But I think the theme here ultimately is, because of their complete lack of awareness,
Right.
everything needs to be recorded,
Yes.
because they will say something like they're being bullied, and you might, you might feel like there are being, I mean, let's put it like this. I was so getting, yeah, of course they said this is the last thing I was going to say, and everybody knew it wasn't. But I'll just say, I, until I listened to the recordings and until I listened to read some of those comments, I really thought that I was the bully in the room.
Because that's the way they want to paint you, and they will villainize you, and they will villainize even somebody who's just sitting there watching. They've done it to me several times too, including when I went to the Garcia Hoven hearing. They claim that I'm intimidating witnesses just by sitting in the room. um
Or Dr. Holliday claiming that he was afraid that he wouldn't get home to his wife and
right,
kids because
right,
of you. I think
yeah.
that's the epitome
He's
of all that.
3 times my size, or maybe even 4, height and weight, and he works in Milwaukee Public Schools, for goodness sakes. So like, he's seen some behaviors, but I walk in, just the mere presence of my name, he wants people to believe that I'm going to, you know, take his life from him.
Because they're literally afraid. That's how afraid they are of the First Amendment. That's what I'm drawing from that.
Ridiculous. In any case, all right. Well, we'll cover more on that stuff later.
Somebody had to push the button, and I think I did it.
Okay,
So
we're done.
where did like somebody?
Is it theme music
Do you want?
going?
Yeah. Do you want to say it? Should I say it?
Oh, you can say it. No, don't say it.
Stick with us. We'll keep you
Oh,
informed.
there you go.
Yeah. Okay.
I thought you were going to talk
Yeah,
about.
we bring this act all over the state. Don't worry about it.